Ready? Exercise number 55. Ready? Start. Learned counsel further argued that the impugned judgment is not sustainable, as the means profits oblique damages awarded to the respondents is not based on evidence but only on conjecture. In the name of taking judicial notice, it is argued that the judicial notice is to be taken only of increase in rent year to year generally, but judicial notice of absolute rental values cannot be taken. In support of his arguments, learned counsel has relied upon the judgment of this court. Electronic Company Limited versus Motion Pictures Association. Learned counsel submitted that even the rental in the year 2005 for an independent residential property in South Extension Part 1 area was rupees 75,000 pm. The rental for an apartment of 2,500 square feet covered area is rupees 60,000 pm or rupees 24 per square feet. Learned counsel for the appellant also points out that the rent from rupees 14 to 15 per square feet has been increased to rupees 16 per square feet, where the property being residential property and being misused as commercial property, the rent cannot be more than rupees 15 per square feet. Learned counsel contended that the future means profit awarded 1.75 lakh pm by the learned trial court is exorbitant and on the higher side. Learned counsel for the respondents, on the other hand, has argued that the documents adduced by the appellant in support of his case are fabricated. Heard learned counsel for the parties and perused the documents relied upon the lower court record. The appellant was paying rupees 90,000 pm, rupees 15 per square feet when the lease deed expired on June 30, 1999. It is not in dispute that the appellant paid full monthly rental up to 30/11/2002 when the possession was handed over. In the instant case, the respondents have failed to adduce the evidence regarding the market rate of rent between the years 1999 to 2002. In the absence of any definite material showing market rate of rent of the suit property, this court has no option but to determine the means profits by way of reasonable estimation. Para. In the judgment, national ratio and electronic case in bracket supra bracket complete. The question of judicial notice has been discussed, which clearly states that rent may vary due to number of factors. Nobody can deny the fact that there has been a rise in rent in Delhi and particularly in the area in which the suit property has been located. The respondent oblique plaintiff has produced two lease deeds for the evidence before the trial court of the properties pertaining to NDSE 2 in respect of the commercial properties. Stop.